This is the Bailed Out Podcast,
You have rights. Nobody knows how to deal with the bureaucracy.
where we talk bail to keep you out of jail.
The only thing that saved me each time is I wasn't drunk.
Does that mean you're a really bad driver then?
Hosted by Sean Plotkin, a multi-generational bail agent and 5-star author. And John Roraba, a non-profit founder and attorney who has helped over 20,000 families.
We're not far right, we're not far left, we're very neutral, I hope.
Bail is the balance.
John, what is justice?
That is what the court system is there to establish.
Bailed Out is brought to you in part by searchandmate.com, Turning Leaf, and Angels Bail Bonds. Now, please welcome your hosts, Sean and John.
All right, well, hi, everybody. My name's Sean Plotkin. I'm a bail bondsman and an author and a father and a loving husband. And today we're going to talk about bail bonds and everything with it. I come from a multi-generational family of bail agents. I was born into it. My mother met my father, helping her to translate, or him to translate in some Spanish. So I'm here with my my partner and co-host, John Roraba. He's going to say a little bit about himself. I just wanted to tell myself a little bit more. I'm not a bail enforcement agent. Well, actually, I guess that's accurate. I'm a bail agent that has been a bail agent for so long that I don't have to get licensed as a bail enforcement agent. But people that are new bail agents have to get licensed for that. I own Angels Bail Bonds and searchandmate.com, a nationwide warrant check database. And like I said before, I'm the author of this book, Get Bail, Leave Jail. It's a book that's intended to help the consumer to make more informed decisions and not necessarily call some gruff individual with this conception of who is this and why am I giving them my financial information. My co-host here is John Roraba. Say a little bit about yourself.
Good afternoon. Yes, I'm John Roraba. I'm an attorney. I've worked mostly with trying to prevent bail forfeitures for almost 30 years now. I had the good luck to go to law school with a bail agent, and I started working in law school with with his attorney as a internship, and I was estimating. I think I've reviewed over 100,000 files. I've gotten more than 20,000 bonds exonerated, somewhere in the $250,000 range. And each one of those has a family behind it. Some family that has pledged that a defendant is going to court, or they're going to pay an outrageous, huge penalty. And I make sure primarily that the court does everything they're supposed to be able to make sure that that the bondsman and the family have a reasonable chance of catching the defendant and bringing them back if they fail to appear. Also, we do a lot to try and help find defendants that have run all over the globe. I've worked with extraditions through dozens of countries. Sometimes they take a very long period of time, but if you're released on bail, and the bail agent's one of my clients, they only pay one judgment for about every 1,000 bonds they write. The rest of them either never fail to appear or they bring them back within a year. And I think that's really important for public safety and for the ability of the criminal justice system to work. I'm particularly focused on the advantages of bail over government pretrial. Which
Do you want to talk a little bit about Turning Leaf, and we can get into more about bail with it?
Absolutely. So Turning Leaf is the nonprofit that I started a few years ago when California tried to get rid of bail. And I realized that families still needed to have the ability to secure themselves for when defendants get out of jail. Thankfully, the voters agreed with Prop 25 and brought bail back, and it's here, and it's still competing with the government pretrial systems. But California's crime has really spiked because of that, and Turning Leaf is designed to help the families of the defendants who are arrested and the victims, but those families that have really stood up for a defendant on a bail bond, they need support, and there's a lot of nonprofits that I hope to work with to get them that support. And if the defendants' families are supported, the defendants are hopefully able to get out of the circumstance that led them to arrest and become socially
No, I agree with you
connected
100%.
people.
I think part of the reason we've come together for this show, this podcast, which we're glad you're watching, and we hope you don't change too quickly on us, is because we both have a wealth of experience in bail. I'm more in the trenches, dealing with the day-to-day customer and the client and the loved one that needs to get their loved one out. And John deals more of the back end to make sure he's a little bit more of the offensive line and the quarterback and the coach all in one. Whereas I'm the running back that just goes to the jail, gets them out, makes sure they're going to go to court, and maybe a safety. Maybe I'm going to make sure that they're not going to do anything bad down the road. But John and I did agree that there's been a lot of negative sentiment with bail. And in my intent for writing the book and then further pursuing the podcast is to educate people more about bail, what it entails, and how it is. So as I was hearing John speak, and he has 35 years experience in this, when he's talking about a defendant or a pretrial or Prop 25 or anything, I'm like, okay, well, I know it because this is what I do, but I don't think you guys know it. So we wanted to talk a little bit more about what bail is and what some of the common problems that a person would face are, some of the misconceptions of what they are. I would say to start with, you had mentioned a defendant. Well, a defendant isn't a defendant until they're a inmate, right?
Well, they may not be a defendant until the complaint is filed, but they're certainly at the time their arrest. They get their rights. You have the right to remain silent and so forth that we all know.
Yeah. Well, do we all know? I mean, do we know what being Mirandized is? Do you want to go into explaining what being Mirandized is? And that's even before you get arrested. You have rights. I mean, even though with the world and everything, we think our rights are being encroached on, let's try to explain our rights a little bit more so we can try and stay out of jail.
Absolutely, absolutely. But that's really where bail starts, is with an arrest. You've been arrested and I've always said that the real problem with the criminal justice system is the crime. I mean, you got to focus that there's been a criminal act here and somebody's been arrested for it. We don't know if they're guilty or not. We don't know what they're guilty of. We need a process. American law is about the process. You've got to have a way for that process to take place. And you've really got two fundamental choices. You either stay under the control of the government, either in custody or with conditions when you're released, or you have a security, either private or amateur or professional security to provide a penalty if the defendant fails to appear.
And that security is also known as bail.
That bail is security, exactly. So the state has an interest in making sure that if there's a crime, that it can be addressed and appropriately. So the state can ensure the defendant is going to show up to trial just by holding them. They could just hold them in custody the whole time. But it's very expensive and it's very hard on the families. And so bail actually, in my opinion, works better as long as it's secured properly because it's much less expensive and it provides a much better opportunity for due process because the person can defend themselves. When you're held in custody, and you've just been arrested, it's really easy to just enter a guilty plea and to waive those constitutional rights that you have.
Well, you have an opportunity cost. You want to get to work. You want to be able to take your kids to school. You want to help with your papers. Oh, wait, no, my loved one's in jail, so now I got to handle the load all myself, and there's not an income coming in. So wait a minute, why don't we just accept what we're given to be able to get back to our way of life? But isn't that what public defenders are for? And I mean, is there? But
well, they do. Public defenders are important, and it's an important part, but you usually don't get appointed the public defender until after your first appearance in court, which is somewhere from weeks to months after the arrest and and you've been, and or released on bail. So there's a shorter period of time to go to court and have a trial if you're in custody than if you're released on bail. So because both you and the state have a little bit more time that way. I've seen people stay in custody for years at a time before they're even convicted.
Yeah, long-term holding facilities. Also, once somebody is bailed out, then the court date is extended further into the future, being able to give the defendant, who was formerly the inmate, that now, well, assuming they're going to press charges, sometimes there's a district attorney that may choose not to press charges, where there may not be a trial. So now the inmate becomes, well, we call him the defendant, but if there's not actually a trial, then it's not a defendant. So we would just call our customer, or
The
yeah,
arrestee.
the arrestee.
I think
Yeah.
that's the good language for that. But
Can you explain a little bit more about what a DA reject is and when a district attorney chooses not to file, but still could file in a period of time? So, yeah.
certainly, absolutely. So when you the timelines are different if you're in custody or out of custody, but the district attorney within a relatively short period of time has to file a document saying what the acts that you did that were wrong and what statute you violated. They have to be able to put that in writing and then have a good faith belief that they can prove those cases. That's the filing of the complaint. And when the complaint is filed, that's actually when the defendant becomes a defendant, and the arrestee becomes a defendant at the filing of the complaint. But that can be very different than what the arrest was. When you get arrested for something, the officer chooses what he thinks crime you may have committed, and that's what the bail is going to be based on, is the officer's arrest, because no complaint has been filed yet. It's different than in the federal courts where they've investigated cases or have a grand jury. Here, the kinds of cases that we're dealing with mostly are drunk driving or drugs or domestic violence or an assault or something that just happened and now the person's been arrested. And so nobody knows what's really going on at the time. And there's many arrests where the police think something happened and something different happened. And the DA has to look at the police report and decide, is this something that meets the standards to file a charge? If they never file the charge, you may still have been in custody on bail for weeks or months. They never filed the charges, but well, if you're in custody, they have to do it a little faster than that. But
I mean, they have a right to speedy trial, right?
They do have a right to speedy trial, yes.
But to that point, a DA reject would be when the district attorney doesn't have sufficient information at the time to proceed to pursue your case. However, that can happen in a number of weeks. And subsequently, the DA may get more evidence. So if you had committed a crime, and I'm not an attorney, I'm not giving legal advice, but if I was charged with a crime and I got out and I had a DA reject, I'd keep my mouth shut. I wouldn't say anything because the DA can go and refile the paperwork within 1 year. And, it's happening more often now with COVID opening up. It's like, oh, wait. Hi, Sean, can you please reassume the liability on this bail bond? And my clients ask me that. And what is a reassumption? That's when a bail agent is willing to reassume that you're going to guarantee in court. And some bail agents are like, well, let me look at your case, because if there wasn't a filing, but there is a filing, then there may be a change from the parameters of what you were arrested for to be what you're charged with. So you've got to be open with your bail agent and your attorney so that we can work together and make sure that everything works out better. Communication is key.
Well, and that's one of the things that happens with bail all the time is you have to decide whether or not to get someone out of custody, and you don't know whether or not or what the DA is going to file at the time you're making that decision. There's a lot of instinct that you have to be able to use in those circumstances, because that's just the nature of crime. That's the nature of how it occurs. But to me,
well, not just crime, but also how they want to prosecute the perception of crime, and then the path that they think that they would want to take that would be able to help to get a guilty verdict. Like there are crimes, or there's perceptions of crimes, and then there's evidence which may or may not be sufficient. I don't know, what's that, exculpatory evidence? Or
sometimes exculpatory, meaning to show that you're innocent, that you didn't do it.
Yes. So, I mean, there's a whole lot of other factors that go into that. So what else do we want to talk about with bail that there's a lot of misconceptions in?
Well, I think that to me, the heart of bail is when you've just been arrested and you're sitting in a jail cell and you've got to figure out what you're going to do. Because the decision that a person has to make at that point is, if you do nothing, within a few days, they'll take you in front of a judge, and you could talk to that judge, and the judge might let you out on your own recognizance even, which is just an agreement between you and the court that you're going to show up. It's your promise. Sometimes they can put conditions on that. They can make you waive your Fourth Amendment rights or wear an ankle bracelet. Sometimes they have onerous conditions that they have, or sometimes they just let you out OR. Sometimes they'll reduce the bail. Sometimes they'll increase the bail. There's a
Do you
lot
want
that
to
can go
explain to
into
them a
that
little bit
hearing.
about the Fourth Amendment, since we're here and you brought it up? And
Well, the Fourth Amendment is your right to not be searched and for the government to keep your places and your papers secure from unreasonable government searches.
Hmm.
And when you're on probation, generally one of the things that you'll have to do is give up that right because you've been adjudicated as somebody who is committed a crime
or even not just probation, it could be a pretrial release condition. Which is that probation, or that's something different?
No,
Probation's after
it's
you've agreed to something, but pretrial release
Absolutely.
conditions, and that
Absolutely.
can happen as well. And that's why it's important to know your Fourth Amendment when many people are for bail reform, and they're saying, oh, we need to increase pretrial conditions and let people be out on their own recognizance. Own recognizance is similar to if you get pulled over by a police officer for speeding and you sign a ticket and you're guaranteeing to the court that you're going to make your own appearance. You are recognizing that you are going to go to court on your own. So,
Absolutely.
yeah.
I mean, you don't even have to go to jail to be released OR because you could just get a citation. That's technically an arrest and a release there. And for a misdemeanor, you might just get cited out.
Mm-hmm.
And if you don't go to court, on that, it can be a crime of failure to appear. But that's an OR release, and really an OR release is the easiest that the courts have. But courts, if you fail to appear on an OR release, you're not likely to get it again. So it really is important. But the other thing that happens when you're first arrested is something called the bail schedule. And the bail schedule is a list of the crimes that are in the penal code and an amount of bail for each of the crimes. Each county does it a little bit differently, but essentially, for instance, if you are arrested for a burglary and the police officer thinks it's a felony burglary and he writes down that charge, there's an amount of bail that's set that you can post right away and get out. Most of the bonds that bail agents post are done on the bail schedule. Every year, the judges get together and they decide for this crime, we're going to have this amount of bail. For this crime, we're going to have this amount of bail. And if you post that amount, you get out of jail immediately. But you don't go to the judge, and the judge doesn't set the amount of bail individually. And if the DA, for instance, files a misdemeanor and you were charged with a felony or arrested on a felony by the officer, this happens all the time with domestic violence, your bail is set at the higher amount because you have the getting out of jail quickly.
And why don't you explain a little bit of the differences between what a misdemeanor and a felony would be?
Certainly. There's three kinds of levels of crime in California. There's infractions like your speeding tickets, and those are just paid for by fines. Then you have a misdemeanor, which can have up to a year in jail and $10,000 as a fine. Some of them are a little bit different. And a felony is where you're subject to custody for over a year or more. And so the different rights that you have in the criminal justice system are often depend on how serious the charges are, because generally speaking, the more serious the punishment, the more process is required. So a murder charge, you can execute someone, but you have a lot of process. You can get a fine from people. You only need a little process.
Makes sense. Oh, what else do we want to talk about?
So, that's really the decision that what I want to talk about is just, when you've got that bail schedule and you're there, that's the fast way to get out. And that's really what you've talked about with, in a lot of, with your book is what's that decision-making process like?
Yeah.
Because in a sense, you're only going to stay in jail for a couple of days and you get to go before a judge and they might give you a better deal.
That's true.
But at the same
Sometimes
time,
a worse deal too.
sometimes it's a worse deal, exactly.
Yeah.
But at the same time, that the even 2 or 3 days in jail is such an effect on the psychology, on your life, on the circumstances. California jails are not pleasant places to be. The federal government has taken most of them over because they were being held with unconstitutional conditions. And so a lot of our prisons and a lot of our jails in California are subject to federal orders.
Yeah, I mean, for instance, we're in LA County. We're in Long Beach right now, filming at podcast place. Shout out. And the largest jail in the world is LA County Jail. So if you guys want to be stuck there for days being processed in or processed out, and I'm sorry, Watch Commander, I'm sorry, the head jail dude. No, I'm not talking any smack, but you got a lot of people coming in and coming out and making sure that they're safe or they're healthy or their needs are met too. So the word to the wisdom, get arrested up in Orange County or get arrested in Ventura, because if you're in LA County, you could be in there for a while. Even if somebody wants to get bailed out, they're like, hey, my loved one's about to get transferred. And it's like, okay, well, where are you at? Well, I'm in Long Beach. Okay, well, we need to get down immediately. We need to post that bond, and we can't even guarantee they're not going to get transferred. And, oh, I'm so sorry they got transferred. Oh, well, how long is it going to be now? Well, it could be 3 days, babe. It just depends if you're on a 4th of July weekend or if there's major changes. And then if it's after 9 o'clock, because there's this 9 to 11 o'clock window where they're doing a shift change. So somehow whenever we're trying to get an update on the bond, oh, it's not updated, it's not updated, it's not updated. But really, I think that the people that are going to give us the update really just don't want to deal with it, and they're about to change their shift. So you're stuck there even longer.
Yeah, and that's sometimes even after you've posted the bond. You
Yeah.
know, it is a difficult process to get it out of the jails. But the fastest way overall to get out of jail is a bail bond. And the reason for that is that there's different kinds of security you can post with the court. So, for instance, if the court sets $100,000 as your bail, you could walk in with $100,000 cash, give it to the jailer, and they would let you out. And if you go to court, at the end of the court process, they'll give it back. That's really what cash bail is. And cash bail,
And people have tried. People have tried many a time, and the jails are not taking it.
I think they have to take the cash. Do they not take the
It
cash?
didn't work out, no.
No.
And they're like, oh, I have cashier's check, I have cash. Jailers don't want anything to deal with that. So
Wow. Yeah, I mean,
it's
they're
happened 3 or
required.
4 times.
Yeah, they're required to take that. You could even go in with government bonds, and they're supposed to take that. But the problem with anything other than cash and a surety bond is the court has to approve it first. You have
And a
to
surety bond, explain a little bit about what a surety bond is.
Sure. The surety bond is essentially what a bail bond is. A surety just means like a cosigner. The insurance company and the bail agent are co-signing with the family so that the defendant can get out, and the court knows that they'll get their $100,000. It's an insurance guarantee, or a guarantee from an insurance company is what a surety bond is. It's really not insurance because it's not written with the expectation that there was going to be a loss. Like, we know that there's going to be car accidents, so your car insurance is different. No one ever has to fail to appear. Everyone can go to court. It's more like a bank loan. Everyone could pay it back, right?
Yeah.
And so there's no expectation of loss in the writing of the bond. It's all supposed to work out, but we know that people fail to appear. And when that happens, you've got to get the bond. You've got to get the defendant back. So a surety bond can also be non-professional. And like in the federal courts, they just make the family put their house up. Yeah. And their house has got a deed of trust. And the federal courts deal with much more sophisticated, bigger cases where they've done a lot of investigation first. So they don't use a lot of professional bail agents. But the problem with that is you've got to prove the value. It has to be more. You have to have it. You can spend many days in jail. Whereas if you work it out with the bail agent and you use the bail schedule, you'll generally get out much faster than any other means.
Yeah, and to that point, a bail agent will accept any form of payment that you're willing to work out, and they're willing to accept. For example, I've taken tamales to help pay for a premium on Christmas.
Yeah,
and everybody in my office was stoked to have some really great tamales. We had a fellow who couldn't pay, and he painted cars. So he painted my car.
Oh,
he
cool.
painted my civil attorney's car. He painted my buddy's car. He hated it, but he got it done, and he didn't have to pay.
Yeah.
With cash, and he paid with his means. We had a fellow who got too many times being drunk, and he had to pay for getting out of jail for that. And he was a gardener, so he was our gardener for 4 years. So
So it's
That
really
goes
like a
back to the
chain.
social fabric that you spoke to.
Exactly. And there's a
Yeah.
chain of trust here. The court has to trust that you're going to come back to court, and they trust the professional bail agents and the insurance bond that they post, because they know that you're financially solvent and you'll try to avoid the penalty by bringing the defendant back.
Yeah.
Right. So the people ask, why is bail as high as it is? What is bail really for? And to my mind, the real purpose of bail is to make sure people show up in court. So how much are we going to need to catch them to bring them back?
Yeah.
How much of a penalty does the family have to give the defendant up to come back for the process, rather than paying the penalty, right? It all has to do with the proper functioning of our criminal justice system.
Which goes back to, there's a lot of negative sentiment in California and why there have been movements for bail reform or bail reform measures. And ultimately there was a referendum meaning it passed and then got repealed. But with bail in California, I would argue that it's not really bail that's the problem. I'd say it's the bail amounts are the problem. And I'd say it's the framework of the jail system, where people that are working with the jails, I mean, they need to make an income and they need their insurance covered and they need everything else. But I'd say the majority of the people that we bail out probably should be out of jail, and they shouldn't be in jail. Of course, there's an element that should be in jail, but how do we help espouse some of the positive benefits of bail and how it does take a load off of the taxpayer and off of society by indemnifying them? And indemnifying is when we are stepping in to help guarantee the appearance in court. That's John's actually helped me on bonds where judges have ruled that, all right, well, they appeared in court, but they didn't do this and this and this. And well, no, our job's to have them appear in court, but all right, that's something
Yeah,
else.
exactly. That's one of the ways you can cure a breach, by bringing the defendant back to court. That'll exonerate the bond. Um, the setting of that bail, though, in the amount of hundreds of thousands of dollars, has been found recently to be unconstitutional by the California Supreme Court in the process that they set. They weren't setting up enough process to set people's bail, and so now they've improved that. They have to go through and do a much more serious process to set bail if you go to the court to have the bail set. They're still using the bail schedules. And the bail schedules did get up higher, and every year each county sets those bail schedules individually. San Francisco had a federal lawsuit where they found that those bail schedules were unconstitutional, and they're not using in San Francisco in the same way. But it really has to go to what it takes to make the process bring the defendants back. There's so much uncertainty with bail at the time of the arrest. When you've got someone on an arrest and the police officer says it's a felony and it says it's a charge, there's no information that goes against that. For instance, we're required to have a presumption of innocence, but for setting bail, the judges are required to assume that the facts are true, because we don't know. And that's why the bails get set as high as they do, is because in some circumstances they're necessary. And if you go to court, you don't have to pay it. It's just the incentive to make sure you go to court. And if you don't go to court and they forfeit it, bail agents get 6 months up to a year to bring you back. And they're very active in doing so, because they've agreed to take the penalty for the defendant's failure to appear. It really is, bail is really about the agreement to take somebody else's penalty. And that's the noble element of it. Bail agents, they have to make a decision on very little information, often very late at night. Am I going to stand up for this person? Is this somebody whose penalty I'm going to pay if they don't go to court?
Yeah, no, I'm with you there. You'd hit on the Fourth Amendment a bit. What about the Eighth Amendment?
Yeah, the Eighth Amendment is interesting. There's the federal Constitution prohibits excessive bail, and but doesn't require bail. California's Constitution, which was written later, actually requires that sureties, not necessarily commercial bail, but that you be able to be released to a surety to your family as a right under the California Constitution. Under the federal Constitution, you're not allowed to have excessive bail.
And so, with the Amendment in California, you don't need to have commercial bail, but you can. So, explain that a little bit more.
Yeah.
I'm trying to process.
So commercial bail is a California invention. It came up in the gold rush in the saloons when the attorneys couldn't get their clients out of custody because they didn't have their family, and bail had always been about the returning of the defendant to the family during the criminal process. The family would take the penalty the way the federal pretrial still works with having the deeds of trust generally against the family's home. The repeat the question.
San Francisco.
Oh, San Francisco. So commercial bail was started in the tavern where the bar owner said, "Hey, you don't have family to be able to get the defendant back. Just give me a little money and I'll stand up for them." And he agreed to essentially be the paid indemnitor for the defendants, and it became very powerful.
And an indemnitor, as we had said before, is somebody that indemnifies someone else to guarantee they're stepping in.
Right.
So, yeah.
You didn't have the family, so now you got the saloon owner.
Yeah.
And the McDonough brothers, and it became so powerful. Actually, by the 30s, they had in some ways just taken over the California criminal justice system, and they got the licensing and regulations to limit some of that, because when the defendants are released to the bail agents, they're released to the bail agents before they go to court. So there's oftentimes more opportunity to help than much later in the system, whenever they've been convicted or when they've gone through the process. But the commercial bail is somebody, a professional bail agent, who is paid to stand up for the defendant, whereas surety bail is just the family doing it on their own.
Got it. Saying, for example, I've had defendants that have been in custody in court, and they're handcuffed or they're behind an enclosed area, and they're sitting there and sitting there and sitting there, and then I'm like, okay, well, I'm going to post bond at the court, and the bailiff's like, here you go, and the guy's like, well, wait, I don't have to be behind bars, and I don't have to have handcuffs on. I'm like, well, I'm responsible for you. The bailiff handed you off to me, so now you're my problem.
Yes.
Let's get this figured out. So.
Yeah, exactly so, exactly so. But every place where commercial bail is allowed, it's the dominant release system. Because it's faster. You having that professional support for the family is more effective. It gets more people staying in court, and those who fail to appear, it brings them back better. The commercial bail with professional bail agents is just it's the least expensive and the most effective pretrial system.
So, speaking of the pretrial system and the criminal justice system and all these systems, how do we think the bail would interplay amongst the court system against the criminal justice system? I'm biased, but I would argue that without bail, you're not really going to have court or even jails. Like, it all is so intertwined. Like, you can have a court. I don't know. I need to hone that thought more, but I think that it's so foundationally necessary.
Well, the American justice system is very process-oriented. If you look at our constitutional protections, it's really that you have the right to go through a process before you're punished.
Innocent until proven guilty.
Innocent until proven guilty, and all of the protections that we have, from the Fourth Amendment to which keeps you having privacy in a zone of privacy from the state, or the Sixth Amendment that requires you to have a criminal defense attorney appointed if you can't afford one. Those things are all process oriented, but without bail, your process can't work. Or it doesn't work as well, because either you have, profound disabilities on the defendant and the family by holding someone, and profound cost to the state for holding them in the jail pretrial, right? Or you have, if they're released on government pretrial, you have a great deal of expense and also the government impinging upon people's lives when they really haven't. we have all these protections because the governments have abused their power.
But what was the other amendment that we were talking about before? Was it the 14th or the 16th?
13th.
13th.
The 13th
Yes.
Amendment, yes, yeah, the 13th Amendment as well, there's that movie Lincoln with Daniel Day-Lewis that's about the 13th Amendment right after the Civil War. That was really the most important thing I think that Lincoln thought he did, is he couldn't have people re-enslaved after fighting that war. But it didn't completely eliminate slavery as people think. It just limited slavery to having a criminal conviction.
And to that point, that's where we think that a pretrial release is not slavery. But if you're being forced to comply with certain conditions prior to being found guilty, then you are moderately being enslaved in some ways.
Well, look, it's a question of what does slavery mean. I think I want to have a whole podcast on this because we're doing the Juneteenth celebration for the Kingdom Day Parade, the Martin Luther King Jr. Day Parade that we moved from Martin Luther King Jr. Day because of COVID into June 20th, and that's a celebration of the limitations of slavery. Some people will say it's the end of slavery, but in many ways, the reason the state has the ability to imprison people and to hold them from their family is still they've had a criminal conviction and they can be enslaved. And an incarceration is considered by many to be a form of slavery. And if you're going to use slavery as a remedy, doing it before the conviction, I don't think makes sense. I also, I don't think that the remedy of incarceration should be used as broadly as it is. Those things that were a crime in 1860, or 1865 when that was written, I think you should limit the kinds of crimes that you can be imprisoned for. But that's something that's a public debate. I mean that's how California has used imprisoning in a which is more than almost any other culture at any other time. We've let a lot of the prisoners go now, but we've done it in a way that hasn't been safe for the public.
Yeah, no, I was seeing a newspaper article today about how the United States Postal Service is choosing not to deliver some packages in the city of Santa Monica.
Wow.
It's just they're getting abused, they're getting packages stolen, they're getting scared. And I'm like, what is going on with today's world? I mean, a postal worker's got to go home to his family, got to deal with stuff. He's got to deal with. I think they were talking about people hitting them with broomsticks and stuff. It's crazy. Yeah.
Yeah. And it's very different when you've got a defendant who is out on government pretrial and when they're out on bail, because there are certain communities that don't like to call the police, when there's a problem, even with one of their loved ones, because they don't, there's been a breakdown, a lot of the trust with police.
Why don't we get back into some other stuff so I can talk more, since I'm not talking enough? So ask me some stuff and I'll get into it more.
Certainly. So when the defendant is in custody and he's got that bail schedule and it's a large dollar amount, what do you tell them when they're making that decision? Do I want to get out of bail or out of jail quickly, or how does that process work?
I like to assess how much the money really matters to them. I say, hey, I've been arrested a number of times and I've been okay in jail. Are you okay parting with this money? This money is going to be used for me to guarantee to the court that your loved one's going to appear in court.
Right.
Once that person's out of jail, my service, the first part, has been rendered. You are out of jail. Now I'm responsible to make sure that you go to court. You make all of your court appearances. So I like to, in my underwriting, make sure that this isn't going to be a life and death, like, oh, this is my last penny, or I had to borrow it from here. And we've done a number of bonds where people have had to borrow or ask, and it's like, are you sure you want to do this? Because, I mean, at the end of the day, I don't want to have somebody call me a day or a week or a month and go, we really needed that money for rent. And now, okay, well, maybe you should have let your loved one stay in jail for a couple days, maybe a couple weeks at most. But so we like to underwrite to make sure generally what they do for employment. If they're not employed, then who we're speaking with, whether it's a mom, a dad, an aunt, uncle, grandma, grandpa, priest, landlord, best friend, military. We like to speak to commanding officers, be able to see what stability do people have in the community? If they're not able to pay, then that's where it's like, okay, well, what do you do? How long have you done it? Do you have any professional designations? Okay, well, why aren't you currently employed? If we get you out or if we get your loved one out, what's the plan? Where do you want to go with this? How do you want to do this? Is there anything we can help with? Not all the way. I mean, we're not wanting to get too involved in people's lives, but there's times where we've had I'm going to use an example where there was a lady that had 6 children, and she was huge on the Dodgers, had a great Dodger tattoo on her body, and and she wouldn't go to court. And I'll be damned if her I think it was her aunt kept putting up the bond for her, and she wouldn't go to court, and the judge just kept raising the bail and then raising the bail, and we'd keep getting around. We're like, stop, not going. To one point where one of my head bail agents, Maiken, shout out, she literally had to stay in a motel with her for 40 hours to make sure that she woke up, and we took her to court, and we said, here you are. All right, judge, can we please push for bail reduction? She's got extenuating circumstances, and we were able to get it down. But if she continued just doing poor judgment and a poor judgment chain, the bail goes up.
Yeah,
and it goes up. And it goes up.
That's a good point.
Yeah.
You know, every time when judges,
and we got to wrap it up soon.
For sure. But in a sense, it's a matter of respect, right? If you've promised the judge you're going to go to court and you're not there, you know, if you're not there in a $50,000 bond, they're going to make the next one 100 or more. They often will double it every time.
The judges want to be respected, everybody.
That is absolutely true, and you got to go to court. I know that there's a lot of other things that are difficult, you know, in that circumstance, but you can go to court. You can make it, and the courts really will work well with you if you go, you know. And there's you may do jail time, but California law has many outs that you can get with diversions and with probation and with parole if you can really just have your family and others help you with the issues that you were arrested for. I mean, there's a problem there. If you were arrested, there's a problem. You need to get help. You need to get it figured out. That's what I want to do with Turning Leaf, is to help bring those who know how to help with the rehabs and the nonprofits and all of those community organizations that we have, making alliances with those and the bail agents so defendants can get the help they need before they go to court the first time. Before they go to court, because the more attention you give early on these circumstances, the better it is. A lot of times you just have people who are broken in their life.
No, I agree. Is this, should we wrap it up? Cool. All right. Well, then, you have any key takeaways you've gotten from the episode?
Yeah. You know, bail is just critical to our infrastructure. It is the thing that makes the criminal justice system fair. It makes it operate. It's best for the defendants. It's best for the families of the defendants, and it's best for the state. It's best for our citizens.
And I think my key takeaway is, if you're going to get arrested, try not to get arrested. And if you're going to be there, don't say anything. And if you're going to say something, just be respectful. Keep your head down. Keep your smile. So if you want to listen to us on Spotify, Apple Podcasts, Google Podcasts, or wherever you listen, remember to follow us, rate us, and review us. Our podcast is made possible by my bail company, Plotkin Bail Bonds and Angels Bail Bonds, as well as my nationwide search database for people that don't know where their loved one is, but if they think they have a warrant, you can go on to searchinmate.com, as well as John's labor of love, Turning Leaf, which is to help families to be able to take care of their loved ones. Also, if you're interested in the book, it's on Amazon right now. It's got a lot of good reviews. I think we're almost 100 5-star reviews, or maybe 4 or 3, but on average, we're pretty high up there. Or if you have any bail questions, hit us up at 844-BY-JAIL, BYEJAIL. John,
Thank you so much.
Thank you so much.